Good morning, everybody, and welcome to The Box. This is the first edition of The Box of 2022. The Box is Mills & Reeve's webinar series for insurance brokers, intermediaries, and their insurers. My name is James Thompson. I'm a principal associate in our insurance disputes group, and one of my specialisms is defending claims against insurance brokers and intermediaries. I'm delighted to be joined this morning by my colleague Rachael Hendry, who is an associate in the Insurance Disputes Group. And this morning, Rachael and I are going to be talking about the High Court's recent decision in the case of Berkshire Assets West London versus AXA, which is the first English judgment on the duty of fair presentation under the Insurance Act 2015. If you've got any questions during the course of this morning's webinar, please do input them into the Q&A function, and we will deal with those at the end. Always very happy to deal with questions. Alternatively, email addresses for Rachael and I will appear at the end. And so if you don't want to share your question this morning, but you do want to get in touch, then by all means, drop me a line with your question. So what are we going to be talking about this morning? This case of Berkshire Assets West London versus AXA was not a claim against an insurance broker. It's a dispute between a policyholder and an insurer, but it's a case about risk presentation and understanding the scope of the duty to make a fair presentation of the risk under the Insurance Act 2015. That's an issue that brokers have to advise on every day of the week. It's also a case about moral hazards, and in my experience, that's a term that gives rise to more than its fair share of claims and disputes. So here's this morning's lineup. It's going to be a bite-sized overview of what constitutes a material fact, what is a moral hazard, what's the test for inducement, and the importance of factual and underwriting evidence. And to kick us off, Rachael's going to talk us through the facts of the case.
Thanks, James. As some of you will know, this claim was made under the insured's contractors' all risks and business interruption policy. The insured's investment property suffered significant water damage as a result of an issue with a sprinkler during construction works. The terms of the policy had originally been arranged by brokers for the previous owner and was renewed by different brokers after the insured had purchased the property. Upon renewing the policy, the insured confirmed, in accordance with insurer's policy wording, that, and I quote, except as otherwise disclosed, the proposer for insurance, its partners or directors, or any other person who plays a significant role in managing or organising the business activities have not either personally or in any business capacity been convicted of a criminal offence or charged, but not yet tried with a criminal offence. It transpired that the insured's broker had sought confirmation of this from one of the directors of the insured, who provided this confirmation without actually checking with his fellow directors whether any of them were facing criminal charges. As a result, the insured and their broker failed to disclose that one of the directors was subject to criminal charges in Malaysia in relation to fraud. Although it was not alleged that he was personally liable, he had been charged as a result of his position as a director of another company which had been linked to serious fraud. The charges against the director were later dropped. After this non-disclosure came to light, investigations were conducted and insurers confirmed that they would not have renewed the policy at all if they had been aware of the charges. The wording of the policy paperwork stated in terms that the insured was to make a fair presentation of the risk, and went on, if you do not tell us about any charges or fail to advise of any inaccuracies or omissions, your policy may not protect you in the event of a claim. Although the charges against the director were later dropped, this did not alter insurers' view that there was no cover available under the policy as a result of what they perceived to be a non-disclosure. There were therefore two questions before the court. One, was the fact that the director had been charged a material circumstance for the purposes of the duty of fair presentation? And two, if it was, and if it had been adequately disclosed, would insurers have agreed to provide insurance in respect of business interruption or at all under the renewed policy? Ultimately, the claim for cover failed due to the non-disclosure, and James and I will look at the reasons why on the next slides. Under the Marine Insurance Act 1906, as we all know, a material fact is anything that may influence the judgment of a prudent insurance underwriter in deciding whether to accept a risk, and if so, at what premium and terms. In this case, the judge looked at materiality and how this is dealt with in Section 7 of the 2015 Insurance Act. This Act provides examples of what may constitute a material circumstance and specifies that this includes anything which those concerned with the class of insurance and field of activity in question would generally understand as being something that should be dealt with in a fair presentation of risks of the type in question. Importantly, for this matter, the judge concluded that materiality should be tested at the time of placement and not by reference to subsequent events. Therefore, the fact that the charges against the director were later dropped was irrelevant in this case, as that had happened after the policy had been renewed. Insurers argued that the director's charges in Malaysia did constitute a material fact. The fact of the existence of the charges would have influenced their decision as to whether or not insurance would have been provided, and the charges should have been dealt with and disclosed within the context of providing a fair presentation of the risk. This was the position with which the judge ultimately agreed. It is important to note that insurers were still obliged to illustrate that they had been induced into providing a policy for the insured, and in this instance, they were able to do so with some ease for the following reasons, which James will discuss.
Thanks, Rachel. So we've had a look at the facts of the case. We've had a look at what will constitute a material fact. Now we'll move on to have a look at the question of moral hazard. So what do we mean when we talk about a moral hazard? In this case, we're talking about criminal convictions, but it can equally refer to issues around insolvency or other issues that might be said to go to the character of the proposer. It's a slightly nebulous term, and in this case, the judge confirmed that it has no settled definition in law. We're reliant on the test for materiality under the Insurance Act. Would this information affect the judgment of a hypothetical prudent underwriter? But materiality is a low bar, and the issue in this case was criminal charges relating to a director. It was an unrelated Goldman Sachs company. He'd not been accused of acting dishonestly and was ultimately not convicted. It was not directly related to the risk in question, and lots of the cases that I've dealt with concern things like a director's insolvency relating to another company, or the liquidation of a company that was not an insured entity, but was part of the group or had some relationship to the insured. And where the question that the insurer asks in the proposal form is broad, as it was in this case, is the sort of information that can often get missed. A lot of the time, that's because the proposer genuinely doesn't think that it's something that is disclosable. So this can be a situation where a broker has to understand the risk of not capturing these facts and ensure you're giving adequate advice as to the breadth of the disclosure that's going to be required. One of the issues that comes out of this case and is common is that of hindsight. The proposer says, well, he was innocent, so what's the problem? A number of historic cases were cited in Berkshire Assets and AXA that make clear that a criminal charge is material because at the time the insurer is asked to consider it, they don't know what the outcome is. And the test is whether it's relevant to underwriters at the point of proposal. And it's not a defense for the policyholder, for the proposer, to say that everything turned out okay, so what's the problem? So that's moral hazards. We'll now turn to look at the question of inducement. The test for inducement is set out in Section 8 of the Insurance Act. The test is that, but for a breach of the duty of fair presentation, the insurer would not have entered into the contract of insurance at all, or would have done so only on different terms. The claimant in this case seemed to rely significantly on the fact that there were no personal allegations being made against the director, and that the charges were only being brought against him as a result of his role as a director of a company that was implicated in a large fraud. They also said that AXA wouldn't have wanted to alienate the broker, and if they'd investigated the facts, they would have taken no further action. All of this failed as arguments advanced on behalf of the policyholder. Why was that? What the judge referred to AXA's practice note, which we'll discuss further in a moment. Essentially, the judge said that it was common ground that the branch office of AXA that dealt with the proposal would not have had the authority to write the risk, applying the terms of the practice note. And on that, we'll now turn to consider the importance of factual and expert underwriting evidence. Rachel.
Thanks, James. The judge seemed to place heavy reliance on expert underwriting evidence, as well as the evidence given by witnesses of fact. The judge actually rejected the evidence of the insured's expert, who had considerable experience in underwriting financial institutions, but unlike the insurer's expert, not in contractors' all risks or business interruption policies. I'll come back to the expert evidence in a moment. With regard to witnesses of fact, the judge accepted the factual evidence from one of the insurer's witnesses, who was one of their central property underwriters, and this appeared to be a key factor in his decision. This witness referred to insurers' usual practices, and in particular, which James has just mentioned, an internal practice note which clearly addressed the situation where criminal charges were involved. Specifically, the witness said that if insurers had been aware of the charges before the policy was renewed, insurers would have investigated the charges online. From this, they would have learned that they were criminal charges and of a serious nature. She also said that these would have been of huge concern to insurers, as the internal practice note on disclosure of previous insurance, financial or criminal matters provided that, and I quote, if the client discloses matters that fall within the negative criteria set out in a standard proposal form, the risk would not be acceptable and should be declined. So the effect of the practice note was that if criminal charges were disclosed, the risk would not be insured. She went further by confirming that had she been aware of the true situation, she would have regarded the information as material and declined the request for business interruption insurance. Insurers would also have come off of risk for the whole development. The insured's expert gave evidence that if the charges against the director were entirely unconnected to any allegations of personal wrongdoing, and had been brought purely due to his position as a director of the company to which the charges related, there would be no issue of moral hazard to worry about. The judge was not persuaded and concluded that the charges were material circumstances and that the insured was therefore obliged to disclose them. The moral hazard argument failed. Whilst the decision is not necessarily controversial, it is the first known judgment to have considered the interpretation of the obligation imposed upon an insured to comply with its duty of fair presentation under the 2015 Act. It's also a reminder of the importance of giving full disclosure and for brokers to ensure that they have made all adequate and necessary inquiries of all of those parties who could or might affect the validity of a policy by having failed to give or not been asked to provide information of a material nature. I'll pass back over to James.
Thanks, Rachel. So we've been through the facts of the case. We've looked at how the court treated material facts. We've looked at moral hazards, the test for inducement, and the importance of underwriting guidelines. I just wanted to wrap up with a few key takeaways and sort of practical issues that either as a broker dealing with these sorts of disputes on behalf of a policyholder, or as an insurer where you might be trying to uphold a coverage decision. You're going to want to be bearing these issues in mind. Moral hazards, we are talking about material facts with a wide scope, and the question really is, what questions are asked in the proposal form? Have proper questions been asked around the organisation that's seeking insurance? Does the policyholder really understand what the question is asking and the depth of the investigation and the fact-finding exercise that they need to undertake? That's really a job for the broker to make sure that their client is getting to grips with that. Really important, this issue of hindsight. I can totally see, and I've had clients who would have raised the same sorts of arguments around, well, why are insurers raising this now? Because actually the issue is not relevant, be it criminal, be it regulatory, be it something to do with insolvency. The question is it something that was material at the point of the proposal being made? What could insurers have found out at that time, not subsequently, and not applying the benefit of hindsight? Finally, and this is something that comes up again and again and again, the importance of factual underwriting evidence, so the disclosure of underwriting guidelines, the disclosure sometimes of binding authority agreements, things like that, and also expert evidence, getting your expert right. But I think as a practical takeaway for a lot of the people on today's webinar, actually understanding that an insurer that is reluctant to disclose its underwriting guidelines may struggle to come good in demonstrating what its underwriting position may have actually been. And it's a dispute between policyholders and insurers that I've seen an awful lot of, and I think the Insurance Act has really sort of brought them to the fore, because underwriting guidelines, I think, have become more and more important as we've begun to apply the Act over the last sort of 5 or 6 years. So that was all that Rachel and I had to say. We are very happy to take any questions that you may have. Thank you.
James, we do have one or two, if I might interject at this juncture. If I can ask you a question, please. In this case, the questions that AXA asked were really broad-based. As a result, it's easy to see how an insured can slip up and fail to disclose relevant or material information. Do you think it would have been different if insurers had asked a more specific question? And is the real issue that an insured is supposed to go beyond what insurers have asked?
Yeah, it's a really good question, Harriet. Going to the start, what is a moral hazard? A moral hazard is fundamentally a material fact. Something's a material fact if it's of interest to underwriters. Where underwriters have posed a specific question, your obligation as a policyholder and your obligation as a broker is to answer that question. And so where the challenge comes, where the question is, as it was here, is really broad-based, because then your lines of inquiry and the extent to which you have to go off and gather information is much, much wider. And I think there is a real tripwire there for policyholders in not undertaking adequate inquiries and getting all of that information across to insurers. Where an insurer asks a more limited question that might have, insolvencies within the last 5 years or something like that, I don't think that a policyholder necessarily needs to go beyond the scope of that question, because insurers are telling you with the terms of the question what they consider to be material to them. Now, there may be situations where you think, well, notwithstanding the narrow scope of the question, actually, I'm sat on some information which I feel, would be of interest to underwriters, and that's where you need to have a sort of a practical conversation between broker and policyholder to decide whether or not that additional disclosure is going to be appropriate. But in the main, I think you can rely on the questions that insurers are asking.
Thank you for that answer. But is it up to the broker to explain all of this to the insured? I mean, if the brokers don't do so, do you think that failure will come back to haunt them, particularly if the insured misses a moral hazard type disclosure?
I do, and I've dealt with plenty of cases, claims against brokers which concern these sort of moral hazard type issues, and because the term is fairly nebulous, because sometimes the scope of the disclosure can be broader than policyholders think. I think there is a real danger that material gets missed, and I think there is a job for the broker to provide adequate advice. I mean, it is a broker's job to ensure that a risk presentation is complete so far as is possible. Obviously, a broker is reliant on the information that its client provides, but the broker, I think, does have a job to explain what the scope of inquiry would be, applying any question in a proposal form to the situation. And you come back to the question that was asked by AXA here, where it's really broad. The broker's got to be alive to that and to give some proper advice as to what the policyholder needs to go and do and the kind of inquiries that they need to go and undertake. So yeah, it's a real risk area for brokers.
And do you think that the position would have been different if insurers had incepted or arranged the insurance after the charges had been dropped? Do you think the circumstances then would still have needed to have been disclosed?
Well, yeah, I mean, this comes back, doesn't it, to the sort of situation that I was outlining a moment ago, where you actually you might be sat on some information where you think, well, this might be relevant, but strictly, I'm not sure that I need to disclose it. I think if you apply this judgment, the question is, what do insurers need to know at the point of the presentation? So if at the point of making the risk presentation, the charges have been dropped and the situation has been concluded and has gone away, then it's arguable that you then don't need to make a disclosure. It will depend on the question that's asked, because there could be a question with broad scope which would involve you disclosing an investigation, even if it didn't result in charges. That's entirely possible. So you've got to look at what's being asked, but also make a judgment as to whether or not truly the information that you're sat on is something that you feel falls within your duty of fair presentation. And that can be a balancing act, but it's part of the broker's role to sort of to calibrate all the factors and just work out what are insurers asking, and what's the scope of the disclosure requires.
Thank you very much, James. Well, in keeping with our requirement to keep in time, I'll hand the baton back to you to conclude, and any other questions that are outstanding, I'm sure you'll be pleased to deal with by email afterwards.
Yeah, thanks, Harriet. Always very, very happy to hear from people afterwards. Rachel and my email addresses are on the screen. Thank you very much for joining us today. As I say, the next edition of the box is on the 29th of March. I'm going to be in conversation with Flora McCabe of Lockton, talking about claims broking and all things added value services. So please do join us then. The invite will be coming out soon. And a final plea to provide your feedback right at the end of this webinar. But for now, thank you very much for joining us and enjoy the rest of your day. Thank you.